Welcome to the final stop. It's the 21st and last episode of Season 2 of The Green Bottom Line. And what a fitting way to conclude your season of diving into critical environmental topics. Today, we're taking a deep dive into an absolutely monumental development, something that fundamentally reshapes the legal landscape of climate action. We're talking about the International Court of Justice's recent advisory opinion on the obligations of states in respect of climate change. You sent us some great stuff, the ICJ's own press release, and a really insightful analytical piece. Our mission, as always, is to unpack the crucial bits, give you those aha moments, and make sure you're up to speed on this pivotal ruling, without getting lost in all the legal jargon.
Indeed. And this really isn't just another legal document. It's a unanimous declaration from the world's highest court that's truly rare. What's fascinating is how it pulls together decades of international law and points it squarely at the climate crisis. It's like the global legal system has finally, woven all these different threads together to tackle this one massive challenge.
Okay, let's unpack this a bit, because this wasn't just some dry legal ruling appearing out of nowhere. This opinion, it's really the culmination of a truly global effort. Incredible advocacy, actually. And it was sparked by some of the most vulnerable people on the planet. The whole thing actually started with a grassroots campaign. Pacific Islands students fighting climate change. These were law students from the University of the South Pacific. Back in 2019, they started pushing for this. And amazingly, they convinced the government of Vanuatu, a small island nation right on the climate front lines, to champion their cause at the UN.
Yeah, that's a powerful story in itself.
Right, and that led to this huge coalition, 32 states, co-sponsoring a UN General Assembly resolution in March 2023. That resolution formally asked the ICJ for this very opinion.
And the response the court got was, well, unprecedented.
Totally unprecedented. Just think about this. During the first part, the written phase, 91 written statements and 62 written comments were filed. By states, by international organizations. That's the largest documentary record in the court's entire history. Then came the public hearings, December 2024. You had 96 states and 11 international organizations presenting oral statements. That is the highest level of participation in any proceeding ever for the ICJ or its predecessor court. It even beat the famous nuclear weapons case.
Incredible engagement.
But maybe the most powerful detail really is the unanimity. The court adopted this advisory opinion unanimously. It's only the fifth time in nearly 80 years it's done that. All 15 judges. Different backgrounds, different legal traditions, they all agreed.
Exactly. And that unanimity, like you said, it signals this broad judicial consensus on fundamental climate law principles. It really goes beyond politics. And it helps explain why we saw such a massive global response, right? It shows this deep global recognition that climate change isn't just some policy issue, it's an existential threat. It needs urgent legal clarity. And it's just a testament to collective advocacy, especially from vulnerable nations like the Pacific Islands that started it all.
Okay, so the UN General Assembly basically asked the court two big questions. First, what are states' obligations under international law to protect the climate system, the environment, from our greenhouse gas emissions, for us now and for future generations?
Yeah.
And second, what are the legal consequences if states, fail to meet those obligations?
Right, the core questions.
Now, one of the most significant things in the opinion, something that really shifts the ground, is the court firmly rejecting the lex specialis argument.
Yes, the special law argument.
Exactly. So imagine different bits of international law, like separate roads. Some big emitting states, US, UK, China included, they argued that climate treaties like Paris are a kind of specialized separate road, a self-contained system. They were basically saying other roads, other areas of international law shouldn't really apply to climate change.
Trying to keep it siloed.
But the court said a firm no to that. And this is huge because it fundamentally reshapes the legal landscape. It means climate obligations aren't just stuck in their own little box. They're woven into the whole fabric of international law, which massively expands accountability.
That's a critical point. The court's approach here is incredibly sweeping. It didn't just point to one source of law. It identified multiple sources of binding climate obligations. It really showed how interwoven climate action is. It's saying, like you said, climate action isn't just about the Paris Agreement. It's built into the whole legal system.
Yeah.
From basic environmental duties to human rights, even the law of the sea. It just opens up so many more legal avenues for holding states accountable.
So what do they actually identify? What are these obligations?
Okay, so under existing climate treaties, for instance, States in the UNFCCC, the Framework Convention, they have obligations for mitigation, adaptation, and a duty to cooperate. And crucially, under the Paris Agreement, states have an obligation to act with due diligence. That's a key term. Due diligence to make an adequate contribution to hitting that 1.5 degrees Celsius temperature goal.
So it's not just a suggestion, that 1.5 target.
Exactly. And it means their national climate pledges, the NDCs, they aren't just political promises. The court sees them as legal obligations that have to be designed collectively to actually achieve that 1.5 goal.
Right. And it didn't stop with climate treaties, did it?
Not at all. The court also spelled out obligations under customary international law. This is the law that kind of develops from what states consistently do because they feel legally bound to do it. It means states have this fundamental duty to prevent significant harm to the environment. They have to act with due diligence, basically, take all reasonable steps to stop activities in their territory, causing significant harm to the climate system.
And that includes the idea of fairness, right? Like different responsibilities.
Yes, exactly. It's applied according to their common but differentiated responsibilities and respective capabilities. So, acknowledging that some nations contributed more historically or have more resources to act, and they also have a duty to cooperate in good faith to prevent that harm.
Okay, so treaty law, customary law. What else?
Well, there's more. The court found obligations under other environmental treaties too, things protecting the ozone layer, biodiversity. Then there's the UN Convention on the Law of the Sea, UNCLOS. That obliges states to protect the marine environment from climate impacts. And, very importantly, the court confirmed obligations under international human rights law.
Ah, the human rights connection.
Yes, it means states have to protect the climate system to make sure people can actually enjoy their basic human rights. Things like the right to life, health, food, water. If climate change impacts those rights, your state has a legal duty to act.
Wow. Okay, so that's a really extensive web of obligations. So what happens if a state doesn't live up to all this? This is where it gets really interesting, right? For state responsibility, consequences.
Absolutely. The court was very clear. A breach by a state of any of these identified climate obligations, that constitutes an internationally wrongful act. And that immediately engages the responsibility of that state. It basically shifts climate protection from being just a policy choice to being a concrete legal obligation with real teeth.
And who gets blamed? Is it just about government actions?
That's a key point. The court said states can be held responsible for failing to regulate private emitters. Think about industries, corporations emitting greenhouse gases. If the state doesn't exercise due diligence in regulating them, that failure is attributable to the state.
So it's not just about emissions themselves being illegal.
Right. The wrongful act isn't the emission per se. It's the state violating its treaty or customary obligations to prevent significant harm and cooperate effectively. And the court was explicit. It actually said, failure of a state to take appropriate action to protect the climate system, including through fossil fuel production, fossil fuel consumption, granting exploration licenses, or providing fossil fuel subsidies, may constitute an internationally wrongful act attributable to that state. That's a really profound statement. It directly links government policies on fossil fuels to potential legal breaches.
Okay, but what about causation? Climate change is so complex with so many sources. How did the court handle that drop in the bucket argument? You know, it's hard to pin blame on one country.
Yeah, they tackled that head on. They firmly rejected that argument. The court stated that, actually, it is scientifically possible to determine each state's total contribution to global emissions, taking into account both historical and current emissions. So science allows us to track contributions. And they adopted a more flexible standard for showing the causal link, the cause and effect. They basically said, look, we know climate change is complex. It's not like simple local pollution, but we can still trace significant harms back to specific state actions or failures to act.
How do they break that down?
They look at two things. First, can a specific climate event, like a heat wave, a flood, sea level rise, be linked to human-caused climate change overall? Science, like from the IPCC, often says yes. And second, to what extent can the damage from that event be attributed to a particular state or group of states? That needs a case-by-case look. But the court concluded that even though the causal link might be more tenuous than with local pollution, this does not mean that the identification of a causal link is impossible in the climate change context.
So injured states can actually point fingers?
Essentially, yes. The court said each injured state can separately invoke the responsibility of every state that committed a wrongful act leading to climate damage.
Okay, so responsibility is established, the causal link can be made. What about remedies? What can injured states actually seek?
Once responsibility is established, the full range of remedies under international law kicks in. That includes stopping the wrongful conduct if it's still going on, getting assurances and guarantees that it won't happen again, and, crucially, full reparation to the injured states.
Full reparation, what does that look like?
It can mean restitution, trying to put things back as they were if possible, which is often hard with climate change. So more likely it means compensation for the damages suffered, financial payments, and also satisfaction, which could involve things like formally acknowledging the wrongdoing. All of this provided that sufficiently direct and certain causal link is shown between the state's wrongful act and the harm.
So, connecting the dots here,
Mhm.
the court has basically laid out a legal roadmap for climate justice.
That's a great way to put it. It's saying, yes, you can link state actions or inactions to climate harm. And yes, there are concrete legal consequences, including potentially financial reparations. It's a massive step towards real accountability.
Now, you mentioned something earlier that sounded, well, revolutionary. This idea of erga omnes. Let's unpack that.
Right, erga omnes. This is a really big deal. The court determined that states' obligations to protect the climate system, especially that duty under customary law, to prevent significant transboundary harm. These are obligations erga omnes.
Okay. What does that mean in plain English?
It means these are duties owed to the international community as a whole, not just to states that are directly harmed. Think of it like certain fundamental rules everyone agrees on, like the prohibition of genocide. It concerns everyone.
And the consequence of that designation.
The consequence is huge. It means any state has legal standing, the right to bring a case to challenge another state's failure to meet these climate obligations, regardless of whether the challenging state suffered direct harm itself.
Wow. So a country that isn't directly impacted by, say, another country's lack of climate action could still legally challenge it.
Exactly. Think about the implications. It's like, before, maybe only your next-door neighbor could complain if your factory polluted their garden. Now, with erga omnes, it's like anyone on the street can complain because the pollution affects the whole neighborhood's air quality. It becomes a collective interest.
That really does change things.
And related to that, in the context of treaties like the UNFCCC and Paris, the court found obligations are erga omne part, which means within the club of countries signed up to those treaties, all parties have a legal interest in making sure other parties fulfill their main mitigation duties. This whole concept just fundamentally shifts the structure of international climate law. It moves climate action away from just being about individual state interests and towards being a universal collective duty, legally enforceable by potentially any member of the global community.
And this ICJ opinion, it doesn't exist in a vacuum, does it? It connects to other recent legal developments.
That's right. It fits into this broader, really interesting converging trend among international courts and tribunals. We're seeing a kind of unified legal front emerging on climate. For instance, just over a year before this ICJ opinion, May 21st, 2024, the International Tribunal for the Law of the Sea, ITLOS, issued its own landmark advisory opinion.
What did that one say?
ITLOS established that greenhouse gas emissions count as marine pollution under the Law of the Sea Convention, UNCLOS. And it said states must take all necessary measures to prevent, reduce, and control those emissions and exercise stringent due diligence. So a high bar there, too.
Okay, and there was another one even more recently.
Yes, just 20 days before the ICJ ruling, July 3rd, 2025, the Inter-American Court of Human Rights issued its advisory opinion. And that one, in some ways, went even further. It recognized a just cogens norm against irreversible climate harm.
Just cogents, that sounds serious.
It's the highest category of international law, like a peremptory norm, an absolute rule nobody can opt out of. Think prohibitions on genocide, slavery. So recognizing climate protection at that level is huge. The Inter-American Court also affirmed a separate, autonomous right to a healthy climate, and it said states must adopt concrete, science-based measures to cut emissions.
So across these different courts, what's the common thread?
What's fascinating is the clear convergence. All three courts impose these stringent due diligence obligations, and they link them to a state's capacity. They all accept the IPCC's science as authoritative. That's critical. They all link climate protection to human rights, and they all reject that lex specialis argument, saying climate treaties aren't the only game in town.
So the legal world is really starting to speak with one voice on this.
It certainly seems that way. It reflects this growing global legal consensus. It's a powerful signal that the legal community sees climate change as a matter of fundamental rights and duties, not just, optional policy choices. Although it is worth noting the Inter-American Court went furthest by calling it just cogens. The ICJ didn't go that far explicitly, though it heavily referenced human rights duties.
And you mentioned the science, the IPCC. How central was that to the ICJ's reasoning?
Absolutely central. The court's legal analysis wasn't just abstract legal theory, it was firmly rooted in the scientific reality. They extensively cited the IPCC findings. They accepted, unequivocally, that greenhouse gas increases are caused by human activities, and that the risks of losses and damages climb with every fraction of a degree of warming. The science was the bedrock.
And what about the 1.5-degree target from the Paris Agreement? How did the court treat that?
This is really significant. The court identified 1.5 degrees Celsius above pre-industrial levels as the primary temperature goal under Paris. It didn't treat it as just aspirational, a nice-to-have target. It saw it as the main objective. It determined that all countries have obligations to work together towards the highest possible ambition to limit warming to this level.
And this connects back to the NDCs, the national pledges.
Exactly. This is where it gets really important for national policies. The court explicitly stated that NDC's nationally determined contributions aren't just political promises, they represent legal obligations. And those obligations must align with achieving that 1.5-degree goal. The court rejected the idea that states have total freedom in setting their NDCs. It said their discretion is limited. States must use due diligence to make sure their NDCs actually fulfill the Paris obligations and collectively get us to 1.5.
So it puts real legal weight behind those national climate plans.
A fundamental shift, really. It transforms what many saw as a political aspiration, 1.5 degrees, into a legal imperative. It directly links what countries promise nationally to the global scientific goals. It adds serious teeth to the Paris Agreement framework.
Okay, so let's bring this down to the ground. How does this actually play out in the real world? For governments, companies, finance, even for you listening.
Well, think about fossil fuels first. The court explicitly said that a state's failure to take appropriate action regarding fossil fuel production, consumption, licensing, or subsidies may be an internationally wrongful act.
That directly challenges fossil fuel expansion, doesn't it?
Absolutely. It challenges the legal basis for continuing business as usual with fossil fuels, and it confirms states have these due diligence obligations to regulate private actors, including the fossil fuel industry.
What about for corporations and investors?
Huge implications. This opinion creates significant new legal risks, especially in climate-sensitive sectors. Corporate boards, they now really have to integrate this opinion into their risk assessments, their disclosures, their governance. It's not optional. Financial institutions, investors, they need to reassess the climate-related legal risks in their portfolios because these findings provide a legal basis for arguments that continuing to finance fossil fuels could actually violate their fiduciary duties, their duty to act in their clients' best interests.
And litigation. Are we going to see more court cases?
Almost certainly. This is expected to catalyze a new wave of climate litigation globally. Domestic courts in various countries will likely cite this ICJ opinion. It could strengthen arguments in national climate cases, especially around standing, because of that erga omnes point. We might see more international litigation between states, too, and it could even impact investment arbitration cases involving climate policies.
What about global climate negotiations, like the COP meetings?
It will definitely influence those dynamics. Discussions, especially around loss and damage, will now happen against this clarified legal backdrop that establishes potential duties for reparation. High-emitting countries, they face much stronger pressure now to upgrade their NDCs, and an adequate NDC could arguably be seen as a wrongful act under this opinion. And it gives developing countries stronger legal backing when they seek more ambitious climate finance, particularly for adaptation, based on those duties of cooperation and support mentioned by the court.
So connecting the dots again, this seems like a powerful legal push toward shifting the economy.
Yes, if we look at the bigger picture, this opinion provides a really powerful legal lever, a lever to shift capital and policy away from fossil fuels and towards sustainable solutions. It integrates climate risk right into the core of corporate governance and financial decision-making. It signals a potentially significant market transformation ahead.
Now, this whole effort was spearheaded by small island developing states, SIDs like Vanuatu. How does the ruling specifically impact them? It's a win, right? But are there nuances?
It's definitely a significant victory for SIDs, no question. They were the architects. But yes, there are important nuances. For example, regarding remedies, the court found that SIs, even though they're specially affected or particularly vulnerable, are entitled to the same types of remedies as other injured states under the general rules. They don't get a special legal category of remedies just because they're SIs.
Okay, so no special treatment in the remedy rules.
Not in the secondary rules about remedies, no. However, and this is crucial, the court emphasized that the specific, unique challenges faced by SIDEs because of their geography, their development level, those challenges are addressed through the primary rules of international law.
What does that mean? Primary rules.
That means principles like common but differentiated responsibilities and respective capabilities, the principle of equity, intergenerational equity. These core principles require special consideration for SIs in climate action and international support. So their vulnerability is legally relevant just through those foundational rules.
And what about the existential threat for some islands' sea level rise, potentially wiping them out?
The court addressed that directly. It was a major concern, and its reasoning was crucial here. It suggested that existing maritime zones and even statehood would not necessarily be endangered by sea level rise under current international law. That provides really vital legal security for Pacific Island states worried about literally disappearing from the map.
That's huge reassurance. And what about reparations for the damage they've already suffered?
The court's findings on reparations are particularly significant for SIDEs. By establishing that injured states can separately go after polluting states and seek reparations, it provides clearer legal pathways. Pathways for SIDEs to pursue compensation for climate damages, especially when just restoring what was lost isn't really possible anymore.
So while they don't get a special remedy category, the opinion overall strengthens their position.
Absolutely. The very existence of this unanimous opinion, its emphasis on core principles like equity, responsibility, cooperation, it massively strengthens their moral and legal arguments. Arguments for demanding much more substantial climate action and for seeking reparations and support from the international community.
Okay, so let's wrap this up. As we finish this deep dive and finish Season 2 of The Green Bottom Line, what does this all mean for you, our listener?
Well, to recap, the ICJ's advisory opinion is really a landmark. It's unanimous, it's comprehensive, it throws out that lex specialis idea, meaning climate law isn't isolated. It establishes really extensive state obligations under treaties, customary law, human rights law. It gives us clearer frameworks for state responsibility, for causation, for remedies, and it introduces those revolutionary erga omnes duties, meaning potentially any state can hold another accountable.
And it's all grounded firmly in the science, with really profound real-world implications. Accountability for fossil fuels, for finance, for future litigation. This isn't just some dusty legal document, is it? It feels more like a powerful compass for navigating the climate emergency, moving us away from just aspirational pledges towards concrete legal duties, all backed by the authority of the world's highest court.
Exactly. And that unanimous nature, only the fifth time in nearly 80 years, that just amplifies its moral and legal weight. It makes it incredibly difficult for any state to just dismiss it or downplay it. It really signals a fundamental shift towards enforceable obligations in international environmental law. The court's vision is pretty clear. States must protect the climate system. They must pursue 1.5 with the highest ambition. Adapt, cooperate in good faith, provide reparations for harm.
But it's still an advisory opinion, right?
Yeah.
Not like a judgment in a direct case between two countries.
That's the crucial point to remember. It's highly authoritative legal guidance, but it's not directly binding in the way a judgment in a contentious case would be. Which leads us to the final compelling question for you. In a world where the legal consensus on climate obligations is now so incredibly clear thanks to this opinion, how do we collectively ensure that this powerful, authoritative guidance actually translates into the urgent, ambitious, and sustained action that's desperately needed to protect present and future generations?
A vital question indeed. Thank you for joining us on this deep dive and for your commitment throughout this season to understanding the most crucial issues of our time.